Good morning. Happy Tuesday. Breaking the clouds right now. It's supposed to rain again today. I don't think summer is ever coming. I think we had our summer for a few beautiful weeks. And now we're just going to go spring into fall. Anyway. There was an interesting comment yesterday. In response to me saying that lawyers like to win, the comment was basically that maybe by win you mean it somewhat nebulously, like a good settlement is a win. And yeah, I do. But then he went on to say that more than 90% of all criminal cases end up in a plea bargain, and that doesn't sound like these lawyers are trying to win. And there's a problem. There's always a problem with taking a fact, and 90 some odd percent of criminal cases end up in a settlement or a plea deal, plea bargain, and then making assumptions off that fact that are unwarranted. The unwarranted assumption is that some or all, most or all, I don't know, of those attorneys, and well, number one, that there were attorneys involved in those 97% of cases. How many of those are misdemeanors? Are they counting fines, traffic violations, and things like that in it? Misdemeanors and traffic violations, people are a lot less likely to have an attorney and a lot more likely to settle. You pay the ticket, mail it in, and there's no adjudication of guilt there. They just take your ticket money and figure you're okay with that. Unwarranted assumption. Wow, words are hard. Is that it is the attorneys who are recommending accepting these plea deals. And in every settlement situation, plea bargain, anytime there is an offer made from the opposing party to your client, it is your client's decision on whether or not to accept. You don't have any control over it. You can recommend they accept, you could recommend they not accept, but it's not the attorney's decision. So, of that 90+%, how many did the attorneys not recommend and were accepted anyway? You can't tell me that. And finally, unwarranted assumption number 3, which is actually warranted, but the poster didn't address it, is that on the other side of that equation, there's always an attorney. There's always an attorney for the state. Always. Always. There's always an attorney for the state. I guess not in traffic court maybe, but in any like misdemeanor or whatever, there's always going to be the state is going to be represented by an attorney. Well, okay. Hashtag I haven't checked all the states, so maybe there are weird things in small municipalities that don't, but you get my point. Those lawyers won if they offer a settlement and they get acceptance of that settlement. So there you go. More than half the lawyers won in that particular scenario in some form or another. Anyway, so unwarranted assumptions. To continue on with unwarranted assumptions, in my Discord yesterday, someone made the assertion, and I've seen this time and time again, that if you respond, you're triggered. If someone says something and you respond, that is prima facie evidence that you are triggered. And if you deny that you're triggered, that means you're even more triggered. I reject that. Because you respond, that means you're interested in responding. That's all it means. It doesn't mean that you're upset. It doesn't mean that you're offended. It doesn't mean you're triggered. It doesn't mean you're trolled. It just means you're responding. You can draw assumptions based on how a person responds, etc., but sometimes those assumptions are wrong. You got to remember, especially if you're reading responses, that you're reading with the tonality in your head, not necessarily the tonality in the head of the person who is writing the response. They may have said something in a joking manner. You might be reading it in a defensive manner and imply that they're triggered based on what's in your head, not what was in theirs. And the wrap-up attempts have started. Okay. Speaking of that, there is an idiot, and I use that term endearingly, in my comment section, who thinks he's smarter than I am because he can predict when I'm going to respond to things. I'm going to assume arguendo that he's correct. I don't really care. Yeah, I respond to things in my comment sections that I find interesting. The more interesting I find it, the better response you get. If I'm typing sentences, I find it to be a very interesting subject. If I type nope, I don't find it to be very interesting. Neither way means that I'm triggered, but I am here on YouTube, A, to interact, and B, to make videos. If I interact and make videos, that means I'm doing exactly what I intended to do from the beginning on YouTube. And my underlying goal is to find those interesting topics about law and auditing that I find interesting, not that you find interesting, but that I find interesting, and talk about them. You're not winning if I'm doing what I wanted to do. Well, maybe you are. I mean, if you enjoy what I'm doing, then great. But if you think you're winning because you made me talk about something, number one, you didn't. And number two, it's what I planned on doing in the first place. And speaking of that idiot, he responded in a comment thread that was started on my last video by Picture Perfect. Picture Perfect did the classic shit and split. He said, you're wrong about the law. I was involved in writing it. And he wiped his hands and then he left. And okay, let's talk about that. There are two laws that I brought up. Two, not one, but two laws that I brought up regarding the hop jam and the failed attempts by Timmy to get in there. Now, I did a video on this from a First Amendment perspective quite a while back, a year or so ago. Somebody had done a similar thing. They ended up getting trespassed. And I explained that, well, you know, they're leasing out the event, it's theirs, they can set the rules, blah, blah, blah. Now, I don't research this thing all the time. I just popped into a stream and I remembered vaguely what I had talked about from the previous video I did on Hop Jam. Hop Jam is put on by the Hanson brothers. It is a beer and music festival. That's how they market themselves, beer and music. Sometimes they say music and beer, other times they say beer and music. The music is free. It's terrible music from the live streams that I've heard of it. But the beer isn't. That's how they make their money. They make their money by selling beer. Well, actually, technically, the festival makes its money by charging beer vendors to go in and sell their beer. But that's how they make their money, is the sale of alcohol, beer specifically. It is a festival called the Hop Jam, as in hop for beer and jam for music, that markets itself as a beer and music festival that makes their money either directly or indirectly through the sale of beer. So there were two statutes that I brought up. That one allows the festival to keep people out who are carrying firearms, and I think it's 1290.22. I'm not obviously looking at a computer screen or anything like that. I'm walking my dogs at 4 something in the morning, but it's like 1290. It's chapter 53, section 1290.22 or something like that. It's called business owners' rights. And business owner can choose to keep people out if they have firearms. And if they don't choose to keep people out, it limits their liability, and that's great. There are some exceptions. I've gone through those exceptions, and as near as I can tell, none of them apply. The one that is closest, there's two that are closest to applying. One, you can't keep people from carrying firearms or not carrying firearms, but you can't keep people from possessing firearms in places where you park cars, basically, because they got to be able to leave their firearm in the car if they normally carry and they're going to go into your business. That doesn't apply because the streets are all blocked off to vehicular traffic, and so parking wasn't a thing. At least that's my interpretation. The second issue, the second piece of that puzzle, is that if it's city-owned or government-owned property that is a, park or a wild game refuge, or the other one that's closest is a fairground, not a festival, a fairground, then it gets harder for there have to be specific exceptions, blah, 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 like for sporting events or something. If I remember correctly, again, 4 something in the morning off the top of my head, so you'll have to forgive me. Now, I'm going to assume that a festival that rents out streets is not a fairground. We're not renting out a fairground. They're literally renting out the Tulsa Art District. So that doesn't sound like a fairground to me. It doesn't sound like a park. There may be parks in there, but that doesn't mean it is a park. So, I'd have to see case law on it, but I think that applies. And considering these numbnuts have not tried to get the event enjoined from prohibiting firearms, they just keep showing up, apparently year after year, getting told to leave and or trespassed and or refused entry, and then giving up and going home. Well, what are you going to do? The other statute that I brought up, and again, off the top of my head, it's like either 1271.1, 1272.1, 1272.1, 1271.2, somewhere in there. It's basically you can't carry where alcohol is consumed. Now, this is, I think, the one that they're arguing. This is the one that I believe they're saying doesn't apply. Now, Picture Perfect won't actually post anything to refute me. He's just going around apparently bragging that he has refuted me and leaving it at that. I don't know exactly why. But basically, I'm going to say it's 1271.1 and 1271.2. I could be wrong. Somewhere around in there. It says that you can't carry a firearm where alcohol is being consumed. Now, there is an exception that that one of my favorite bobbleheads, who likes to think that he got me if I respond, he pointed out, because he went on to a Oklahoma attorney's website. He didn't go to the statute. He went on to their website, and their website explained it. That if you go to a restaurant or other establishment that doesn't make its money primarily through the sale of alcohol, but they sell alcohol kind of incidentally, then you're allowed, if you have a concealed carry permit, to carry in that establishment as long as you don't drink. And you know what? The wonderful thing about attorneys' websites is they're generally right. And if you contacted that Oklahoma attorney and he gave you his professional opinion, this dumb fuck first-year family law attorney out of California was wrong, I'd absolutely buy it. But if you just point me at his website, I still have the same issues. And my same issues are as follows. The statute said exactly that. I was aware of that language. Number one, you're assuming that the Hop Jam, the beer and music festival where it's free to enter, but it's not free to drink, you're assuming that that is a restaurant or establishment. I don't know that to be the case. That's going to be a fact-based argument that's going to have to happen at trial, unless it's already been adjudicated that the Hop Jam is or isn't a restaurant or other establishment. I don't know if it's an establishment. It probably is, but I don't know. There may be some legal definition of it. And obviously the attorney's website didn't go into it. But these little pesky facts are just, why let them get in the way when you're just convinced that you're right and you're stomping your foot and declaring victory? The other big issue is that it has to be a restaurant or other establishment that doesn't make their money primarily from the sale of beer or alcohol. And I'm going to point you back towards that pesky fact pattern where the Hop Jam is a beer and music festival where the music is free, the concerts are free, the beer is not. So you can do with that what you will. There may be some caveats. I mean, if it is an establishment, do they draw lines between the beer garden area? Is there a beer garden area? Do people just wander around with alcohol? I've been at concerts in California. Normally have like a 21 and up area, but I don't know. I haven't been to the Hop Jam. My point is that when I'm giving recommendations, I am not acting as an attorney. I am acting as somebody who has legal training, and it is safer for you to not be challenging that while you're facing a felony. Because near as I can tell, it is a felony to carry a firearm in a place where alcohol is consumed. And consumed can mean either drunk or sold. If you're a consumer, get it? Or you can consume liquids. Either way, I think it would fly. But again, if you have a question, talk to a local attorney about it. But here is why I say things like, be careful about this. Timmy found a back way into the Hop Jam through a bar. Timmy found a way in to the Hop Jam through a bar. I saw this on the live stream. And he asked Picture Perfect if Picture Perfect was comfortable with entering the Hop Jam through the bar. Thank God Picture Perfect was there. Picture Perfect wasn't comfortable with it. Timmy, on a live stream, was apparently prepared to carry a firearm on a live stream through a bar, on a live stream, knowing full fucking well you can't carry a firearm into a bar unless you're a police officer. Some exceptions apply, but Timmy would not have been legally able to carry that firearm through that bar. So these are the reasons why I make the suggestions I do. Could you win? Possibly. Could you argue it out on the facts? Possibly. Does the law support your position? Possibly. But is it something that you really want to risk a felony over and all the legal fees associated with it? No. If you want to challenge whether or not the Hop Jam can exclude firearms, you seek injunctive relief. You sue them in civil court in Oklahoma. You hire an attorney, preferably, and you sue them. And you sue them for an injunction against them keeping out people who can lawfully carry firearms otherwise. That's how you do it. You don't show up next year and get refused entry and accomplish nothing but get clicks and views on your video. Anyway, I think I've rambled long enough. Thanks for watching. I hope everybody's poop was good this morning. Have a great day.